Ask not what we all be can do for you. Ask what you can do for we all be.
All right. Please be seated. Ms. Johnson, you got 3 minutes and 9 seconds.
Justice Kitchens, I did want to clarify, earlier we were talking about the gun in question, the .380. I went back and looked that up. If you look at the record, starting at page 2123, approximately, of the trial record, the forensics expert, the independent forensics expert, testified that the 5 cartridges in the holes that were recovered from the crime scene came from Doyle Simpson's gun. Bullet fragments that were recovered from the crime scene either came from Simpson's gun or were consistent with a .380. So I wanted to offer that clarification. Okay, with 2 minutes and 35 seconds, I want to talk about the eyewitness ID by Charles Collins. For an ID to be excluded, we are not disputing that Biggers is a linchpin, but you have to get to an impermissibly suggestive lineup before you reach Biggers. For an ID to be excluded, it has to be the product of an impermissibly suggestive lineup, and it has to be unreliable. If it is not suggestive, pursuant to Latiker v. State, the analysis ends. If it is suggestive, that does not preclude the identification unless the lineup was so impermissibly suggestive as to give rise to a very substantial likelihood of misidentification. The pretrial identification by Collins was not suggestive. The defendant was not conspicuously singled out like he was in Butler, which again in that case the court found that even though it was impermissibly suggestive, it was still reliable and therefore admissible. Flowers was not the only one in the 6-pack matching Collins' description. Flowers was not the only one in the 12-pack matching Collins' description of a black male with medium complexion. The state would submit that that is a relatively general identification. I'm sorry, I thought you were going to say.
Can we take a break when everybody gets a seat? Thank you.
Now, I'm going to ask you if everyone would, this looks like a basketball game or something. Everyone, please keep your seat unless you've got an emergency. And if you do have an emergency and have to leave, stop at the back row, okay? Thank you.
Okay. The police actually, in this case, as the defense noted, Collins looked at the lineup about a month after he made the initial identification. During that time, the police had already started to develop Flowers as a suspect. Now, what they could have done to make the lineup suggestive was to put Flowers as the only person who looked like Flowers in that lineup. They did not. As the state testified and as Collins agreed, they picked fillers to match similarities with Flowers. And so what Collins testified to was that Flowers was one of 3 people in the lineup with the darkest complexions. He was one of 3 people in the lineup with a receding hairline. He was one of 4 people in the lineup with a beard. So, to the extent we are saying the police somehow made an impermissible lineup based on a description of black male medium complexion, when Collins comes back and says Flowers at minimum matches up with other people in that lineup on 3 separate characteristics is to negate that suggestion that the lineup was impermissibly suggestive, that we conspicuously singled out Flowers in some way. The only difference that Collins noted was that in the picture, Flowers seemed to have the biggest head. It's a closer up picture. But Collins said he never described the perpetrator as having a big head, and he stated that he didn't pick Flowers out because of the size of his head. Minor differences do not render a lineup suggestive, and use of a different photographic technique, taking a closer picture, having a lighter background, those are considered minor differences. Batiste versus State. One face larger than the other is not suggestive. If you look at Butler, if you look at Dennis, which Butler cited, which was a Court of Appeals opinion, Dennis, the defendant, said he stood out like a sore thumb when the cop used his driver's license picture, which was a bigger face. And the court said, nope, the pictures just indicate they were taken at a different time and possibly with a different camera. They were not so distinctive as to conspicuously or improperly single him out. The difference in clothing, the size of the picture, the background lighting, all of these things do not render the lineup inadmissible, even where the defendant is described with that clothing. If you look at White versus State.
Your time is up. If you wish to summarize this particular point, I am confident that there's some other questions that the justices will ask when you finish, but I would ask that you summarize your identification argument.
Yes, Your Honor. Thank you. Pursuant to Biggers, I argued Carruthers. The state recognizes that the differences in the reliability between Carruthers and this case, that there are some differences, that the victim had a longer period of time than Mr. Collins did. However, we would note that the defense in Carruthers argued that stress limited the victim's ability to identify. We certainly don't have stress in this case. Mr. Collins had a period of time to observe. He saw Flowers from 30 feet away as he was, quote-unquote, slowly driving. He saw them arguing. He said he was nosy and paid attention because it looked like they were about to fight. From the time he identified Flowers in 1996, until the time of his death, he always said it was Curtis Flowers. He said, I think that's him, I believe that's him, I'm sure that's him. We would also note that in Christmas versus State, this court did not uphold or reject the issue of the 43-day lineup. That was found at the trial court level that 43 days was too long in terms of a reliability factor for Biggers. The only thing that we have from this court is Burton versus State, which has that 8 months weighs against the state in the terms of the reliability under Biggers.
I would ask that you address the issue of jury selection.
Once the defense makes a prima facie case, the state has to provide race-neutral reasons for those strikes.
Did the trial court find racial discrimination in this case?
It found a prima facie case because the state used 5 of 6 peremptory challenges to strike African Americans. The jury was seated at that point.
What do you mean the jury was seated?
They had picked enough jurors at that point. The state didn't use all of its peremptory challenges, and neither did the defense.
So the state only used 6 peremptory challenges in the case,
and the defense used 8.
And 5 of those were.
And 5 of those were against African Americans. That is correct.
So the court found prima facie evidence and asked the state to provide race-neutral reasons,
which the state did. And I think critical for this case, and we can sort of sum up our Batson argument very simply, which was of the 5 African Americans that the state struck, all 5 either worked with Flowers' father or sister, or were sued by Tardy Furniture, or both. And when the trial court asked defense counsel if any white jurors tendered had been sued by Tardy Furniture, defense counsel conceded that the answer was no. And when the trial court asked defense counsel if any of the white jurors tendered had worked with Flowers' family, defense counsel conceded that the answer was no. So,
do you, as a preliminary matter, do you believe that a prior finding of a particular prosecutor's office, someone in the office, whether it's the prosecutor or an assistant prosecutor, a prior finding in a previous case of discrimination is a factor to be considered in the cases before us today?
It's a factor to be considered only in terms of whether or not the defense has made a prima facie case, and in fact, in a State of Jones and in Strickland versus State, the court said that statistical analysis by itself is not sufficient to make a prima facie case, and they said, what else do you need to show? And included in that list is habitual practices of the state, or stated policies of the district attorney's office, or the nature of the case itself. So, to the extent that it went to finding a prima facie case, we would submit that prior history is relevant. Once we get to the issue of race-neutral reasons and pretext, we have to look at the reasons that the state gave, and as long as it is facially not violative of the Constitution, we have met our race-neutral burden.
Why wouldn't it be just as probative, though, of pretext as of a prima facie case?
I'm sorry, I didn't hear you.
Why would not past discrimination be just as probative or as instructive of whether or not a particular race-neutral reason is a pretext as it would be probative of whether or not a prima facie case has been met?
I think that's certainly something that this court can decide. I'm simply stating that what the law is that it is probative for a prima facie case. The defense hasn't cited any.
You're saying that's what the law is?
Yes, sir. Pursuant to Strickland.
You're saying there's a case that says it's not probative of pretext?
No, sir. That's not what I'm saying. What I'm saying is that the defense hasn't provided any case saying it is probative of pretext. And so what we have here, though, the other thing that we have to look at is, again, if we're talking about the differences between Flowers 3, where all the Batson cases came out, and Flowers 6, where we are right now. During Flowers 3, we had some problems in the jury selection. We don't have those problems here. The defense has already conceded that we did not strike any black juror and keep a white juror with that same element. And pursuant to the McGee comparative analysis.
Are you saying that the only way you have a Batson violation is if the parties are 100% identical?
That is correct. Pursuant to McGee versus State, what the court says is that the only difference can be the color of the juror. That is the only difference. So in fact, in McGee, there was no back.
Can that be established by other things? For example, one of the issues raised by Flowers in this case is that there was a difference in the questioning of prospective black jurors and prospective white jurors. And in fact, I think as I looked at it briefly, there did seem to be more extensive questioning of black jurors than of prospective white jurors. I think my rough numbers were approximately 3 questions on average for white jurors and somewhere in the vicinity for 10 on average for blacks. Is that a consideration that the court can look at?
I think certainly it is. I think what you have to do, though, is again look at the situation in context. First, let me say that every juror, black and white, was asked if they had been sued by party furniture. So right there, we have all of the jurors being treated the same. Every juror, we didn't have a single juror who had identified themselves as working with Flowers' family. Now, in terms of the more subtle, nuanced issues, fairness, impartiality, death qualification, and things like that, again, I kind of go back to this word but that I sort of harp on a lot, because what we have here, in addition to those 2 reasons, which the defense has conceded, there were no white jurors struck.
Well,
we had...
with your party analogy, does it make a difference that the state seemingly mischaracterized the evidence as relates to, I believe, Burnside and Wright in the lawsuit as regards party? I believe the state said that they had actually not only been sued, but garnishments had been sued against them as a result of those judgments. And I don't recall seeing anything in the record that suggested that there were, in fact, garnishments issued against them. Is that right?
I do not have any record evidence of that I have been able to find. No, Your Honor.
that speaks to the working relationship between the two of them?
No, sir, there was not. And in fact,
Was there any effort to inquire into the working relationship between them?
I do not recall. I know that the question was asked. I do not recall if it was explored on that point. I know that the trial judge found, he characterized the Walmart as the smallest Walmart in existence. That's part of the trial judge's finding when he talks about the working relationship. Again, though, the reasons are race neutral, and no white jurors were struck that were kept that had those same reasons.
Well, but looking at all of those things together, is it possible that yes, they may be serendipitously race neutral, but they might also serve as a mask for pretext?
Sir, I think that you can infer pretext from pretty much anything.
Well,
But I think at some point the trial judge has to make a decision.
Some of the relationships. There were extensive questions asked, or recalled, of prospective black jurors regarding their relationship with Flowers' family. Am I correct that those same types of extensive examinations were not asked of prospective white jurors? Are we then to conclude that simply because the parties happen to be black, that there's a likelihood of prejudice there in terms of looking at the evidence? Whereas you would not make that same conclusion and looking at prospective white jurors?
I think if you have a white juror and you ask that white juror, can you be fair and impartial? And that
The question was not whether you asked them whether or not they could be fair. My question dealt with whether or not there was the same sort of delving into relationships with prospective white jurors as there was with prospective black jurors.
in all circumstances there was not. But there was a reason for that, and that reason was not purposeful discrimination, and it was not pretext. That reason was to inquire about statements that the jurors had made about their relationships with Flowers, or their ability to judge.
Who worked at the bank, was there any effort to inquire as to whether or not that sort of relationship would impact her ability to serve fairly as a jury, or was it simply presumed?
Every juror,
because she was white.
every juror, even Ms. Justine, was asked, how do you know these people? How do you know the victims? What's your relationship? When she answered that question, the answer was, yes, I think that I could set it aside. I don't know much about the case. I think I could be fair and impartial. And again, what we're talking about is not what this court deems to be right or wrong here on appeal, but whether the judge who was best able to determine the credibility of all the parties and is afforded great deference was clearly erroneous.
Well, let me go back to my very first question to you, since you're talking about great deference being given to the trial judge. This court made a prior finding that there was, in fact, a Batson violation in the trial of this case. Do we simply ignore that as we analyze what's in the record before us?
For sake of argument, don't ignore it. Let's talk about it. What did we have in Flowers 3? What were the differences? The state made outright fabrications with respect to Juror Curry. The state committed plain error with respect to Juror Pittman when it said that she said she didn't want to be there, and there was no evidence in the record of that. The state committed error when it made bare assertions about jurors without any evidentiary support anywhere. Where do we have that here? We don't. So let's take into account that the jury, let's take into account that the judge was required to take the state's past mistakes and look at them in terms of this. One of the issues we had in Flowers 3 was striking people who knew Flowers or who knew the family, and we got into trouble with that. So what did we do here? We stopped. We picked people with the closest connections that you can see on paper. We picked relatives and we picked coworkers. Knowing somebody at the bank is different from working with somebody. Looking at it facially, pursuant to Batson. So even if we do compare it, we don't have the error that we had in Flowers 3. And the trial judge made those findings on the record.
Well, with respect to Juror Cunningham, the prosecution went to great lengths to call an outside witness to testify to the working relationship between Cunningham and the sister of Flowers. And Flowers indicated that it was just a working relationship, that there was nothing close. Is there anything to indicate that it did that self-examination that related to white jurors?
I have no evidence one way or the other. I will say that
Okay, also, still talking about Cunningham, holding the calling of this outside witness, the prosecution asked the court to bring Cunningham back to place her under oath, to question her again about the relationship between her and Flowers' sister. Now, if I recall, an issue was raised about the prosecution of the prior trial having with significant fanfare had two of the African-American jurors charged with perjury. Is there any reason that the prosecution at that point would have needed to recall Cunningham to question her on the oath again about that relationship?
I mean, again, I can only speculate. Perhaps they wanted to call and try to figure out what was going on here. I don't know the answer.
I believe she'd answered the question when she was initially examined by the court.
She answered the question with what the state believed to be a lie.
Excuse me?
She answered the question with what the state believed to be a lie.
Well, didn't they call Cunningham's employer to come in and testify that she worked right next to her, within inches of her?
They did.
The lady had given responses in the board diary that they worked on the same line or same shift, but not close to each other?
There was some inconsistency there. She said that they worked on the complete opposite end from each other. Her supervisor came in and said they worked side by side and less than 10 inches from each other. We would again note, trying to remedy mistakes from Flowers 3. In Flowers 3, this court declined to set limits on the use of legitimate informational sources. So when the state was striking...
Were any white jurors give the same responses that Cunningham did on her written feelings about the death penalty, where she stated, "I don't believe in the death penalty"? We
did not have any juror, any white juror tendered that said, "I do not believe in the death penalty."
Dr. to follow up what Justice King asked, and I'm probably not being very articulate about this, but I think his point on the questions is that if perhaps as many questions were asked to the white prospective jurors as the black prospective jurors, that they would have had other reasons or find out different things, or there would have been or that the state was actually trying to ferret out reasons, race-neutral reasons, instead of, and not with whites.
And I recognize that, and you know that's one of the things that the defense has touched on in their appellant's brief. I will offer you an example with two of the jurors that they talked about, you know, possible disparate treatment in terms of questioning. We asked if certain jurors had opinions about the case, and almost a large number of jurors said that they knew about the case, or you know they had sort of past knowledge based on the fact that this is, you know, a 20-year-old crime with Winona. We asked every juror if they could set aside any opinions, and they said yes. Diane Copper said yes, but I would still lean towards flowers. So when you give that statement, when you give an unequivocal yes, 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 there's nothing else for the state to do. Does the state need to ask, are you sure? Is there anything else that you're not telling us? When the answer is yes, the answer is yes. When someone like Diane Copper comes back and says, yes, but I would still lean towards flowers, that necessitates the state asking another question. The state has to qualify its jury. So we're left in sort of an impossible situation to an extent. Should we ask additional questions of jurors that don't give rise to those questions?
Do you think that accounts for, and I see your point, is that would account for some difference, but do you think that accounts for 4 times, a difference of 4 times the number of questions?
Again, you know, and we're talking about 1,326 pages of voir dire here, so this is a lot of questions that the state is asking a lot of different jurors. I think the issue that we have to go back to is, were there race-neutral reasons given, and was there pretext as a result from that? And the state submits that the answer to that is no. What questions were asked, or the manner in which those questions were asked, that's assuming really deep-seated, really despicable, really deliberative intent, that we somehow, we had a list of questions and we only used those questions for the white jurors and we only used these questions for the black jurors. We're making assumptions here that are not in the record. And
the number of questions is dependent upon the responses, isn't it?
Absolutely.
If the questions let me ask you this, was every member of the denier asked, did they have an account at Tardy's?
Yes.
And was every member, white and black, asked, have you ever been sued by Tardy's?
Yes, sir. Yes, Your Honor.
Right. So now if you get 8 hands, that necessitates
Additional questions.
White or black. Well, explain to me, did you have a good experience, bad experience? That person may only get 1 question, it's a good experience. The other one says bad experience, well, how bad was it? Well, I got sued, but when was that? Then you're going to have 7 or 8 questions.
You are, and what this does, what Batson does, is it's not just a tool for the defense to claim state error. It is a set of guidelines by which the state has to practice. We have to follow these in order to make sure that our side of the trial holds up to constitutional muster. So we take Batson, the judge takes Batson, and we have to use that in employing
Set of guidelines that both parties use.
It absolutely is.
Not just the state.
It absolutely is. So we're bound by those constraints. We know what they are from the beginning. And, you know, we would certainly object to a finding of pretext, to a finding of purposeful discrimination, especially looking at what the judge had presented to him at the time. And what he had was a concession from Curtis Flowers that none of the white jurors tendered had the same characteristics as the 5 black jurors that were struck.
That's what trial counsel said.
That is what defense counsel said, yes.
It is trial counsel.
Yes, that is correct, Your Honor.
All right, you're shaking your head out there, so you be ready to reply to that.
Of course, the defense counsel, even if the prosecutor asked all of the questions to the black jurors and none to the white jurors, the defense counsel, before any strikes took place, defense counsel could have asked all those same questions of all the white jurors so that we would know if there is a difference.
Nothing precludes the defense counsel from asking those same questions. That is correct, Your Honor.
Okay.
Other questions? Thank you, Ms. Dyson.
Thank you very much.
Let me speak very quickly to the identification and then a statement regarding the identification. I do want to say clearly that counsel omitted several crucial facts, but there is no getting around that there was never a statement of he ain't there. He said the guy ain't there. No, he is not. That is not in the record. Nothing close to that is in the record. It is true that Mr. Collins himself said he did not recall having made the other identification. But he never said, I said he ain't there. And in fact, 2 state witnesses, 2 police officers who were there, testified that he pointed to Doyle Simpson's photo and said either it looks like him or it may be him. So in fact, the discrepancy between what the testimony was and what the state said it was is astonishing. The second thing I wanted to point out was that in recounting the sources of suggestiveness, the state has forgotten the most important sources. I do think, looking at the lineup, which is reprinted in the brief, it is beyond cavil that the photo that jumps out at you is that of Mr. Flowers. And it does so on the basis of things that were mentioned by Mr. Collins. But that's not the most important thing. What they omit is to say what happened. What happened is a tentative identification of one person, a new lineup, which of course suggests you got the wrong person, and then a tentative identification of another, after which there's a question, do you know Curtis Flowers? And there's no excuse, no reason for that pointed to him. And that's not true in Carruthers, it's not true in any other case.
What about that word but that Ms. Johnson points out?
But
In the first lineup, that looks like him, but.
well, of course, there are actually 2 different accounts of it may be him. These are really accounts of Johnson and Miller, sorry. And they say that he said slightly different things, but he never says he ain't there. It's not him.
But if he said that looks like him, or suppose he even said that looks a lot like him, but this guy's a little taller, or this guy's hairline's a little different. What would be wrong with presenting another lineup if the witness says that looks a lot like him, but there's a difference or there's a problem? What are they supposed to do at that point?
Well, first of all, they didn't need to do it right then, which clearly suggests to him that he picked the wrong person. Second of all, one would assume they would put in the next lineup the person who looks like him, but, and one certainly would not, upon the same kind of hesitation with respect to Mr. Flowers, uncertainty, then say, do you know Curtis Flowers? That was extraordinarily suggestive in a way that I have never seen in a case before this court, or actually any other case that I know of.
Did those photographs have names on them?
Pardon me?
Did the photographs have names?
No, they did not.
So he did not say, this is Curtis Flowers.
No, but Mr.
Since you're saying when they said, do you know Curtis Flowers, that he had to have known that must be who I just picked out?
Well, he did know, he did say that there was talk in that time in the community
But
about...
who said that?
Mr. Collins said that. He did not recall whether he'd heard the name before. But I think it's actually also a very interesting question, because actually Mr. Collins has said he did not know the person he saw. So the question of do you know Curtis Flowers had no place in that lineup unless it was suggestiveness. There was no reason to ask him that. There was no reason to proceed as they did. It was extraordinary. So I wanted to say that.
Are you saying that when, I think I see your point, you're saying that in the second lineup, when they show the pictures, and he says whatever he says, and then they say, do you know Curtis Flowers, that implies he's one of these people?
Yes.
That's what you're saying?
Yes.
Okay.
In a way that, particularly the disparity between the treatment of the first tentative identification, oh, let me show you 6 more pictures, and the response to that identification, do you know Curtis Flowers? I think those are wildly different, and the implication is that you have the right person. And of course, there's no speculation involved. It actually produced the confident identification. There was no confident identification until he said that. And then, when that was said to him, then he said, that's the guy. So, I mean, I think it's really very difficult to say that it didn't matter, because it occurs exactly then. Right then, first he says, I believe it is him, it looks like him. Then, do you know Curtis Flowers? Then, right after that, the picture that I picked out in the lineup was, right there was the man that I saw from Party Furniture Company.
What are you reading from?
That's from the transcript.
Transcript of what? Of the pretrial hearing, of the trial, of what?
From his testimony.
At trial?
Yes. And I'm sorry, Your Honor, the cites are in the record, I don't, but they're also in the brief, everything.
I'm just trying to understand if you're reading from a law enforcement officer's recollection of what he said or what happened, or from his testimony, or from what it is you're reading from.
I believe that quote actually was the law enforcement officer's statement, his own statement.
It's not like there was a video of
There's
this,
not a video.
or audio, or that you're, this is someone's testimony or recollection about what he said.
Yes, and actually it is the only recollection is that of Miller and of Johnson, because Mr. Collins himself says he doesn't recall whether he identified someone else or not. And I think the other thing that was actually omitted in the recitation of the events was that when he's called to testify at the first trial, he is not certain that it is indeed Mr. Flowers. Even when he's sitting in the chair, he says he didn't have on glasses. They make him Mr. Flowers take off his glasses. Even then, he's not sure. By the second trial, he says, I will always believe that that's the man that I saw at the furniture store. So I'm not saying that he never said that. I'm merely saying that if we're looking at the evidence of unreliability, a piece of that has to be uncertainty. And there was a lot of uncertainty at different points in this case. And so perhaps I should also speak to your question about whether or not it makes any difference, Justice Dickinson, about whether there was they were all in a pile or not. Yeah. And as I said, I think that is the smallest of the errors. But I do want to say that, first of all, while there was testimony by an independent expert that the bullets all came from the same gun, the state crime lab witness actually could not determine that that was the case. So there was some uncertainty about that fact. But I think even if we assumed that they all come from the same gun, it is still much harder to figure out how one person kills three people there and one person 15 feet away with close shots, with no one else in any way restraining the people or pointing a gun at them or anything else. If, of course, all of them are right there, it is you round them all up, you shoot them all right there. So I don't think that that's dispositive. I think it's just one more piece. And I would actually point out that the state is a little bit inconsistent in saying about some of these errors, well, it didn't matter because defense counsel addressed them. But then about this error, saying it didn't matter because defense counsel did not address them. The whole point is that the jury was misled by someone they trust. A prosecutor is supposed to be trustworthy, who made all of these misrepresentations on matters that, especially cumulatively, are ones that alter the reliability of the verdict.
Did anyone make the two-man theory argument, prosecution or the defense? Prosecution, obviously, it was one-man argument. But the defense testimony, was there ever an attempt to argue that there, or his defense, that there was a two-man or more theory to the case?
I'm reluctant to say never, just because there were enough trials, but I believe the answer to that is no.
Okay, thank you.
At least we know that argument was not the defendant's theory in this trial.
That is certainly true. And if I see that.
Are there other questions or identification?
Well, you were shaking your head earlier, Ms. Johnson, regarding what the defense counsel did or did not do at the conclusion of the Batson matter.
I'm afraid that you're asking me this question encourages me to shake my head next time and get a little extra time, but be that as it may. What I'm going to say is, it's true with respect to the question about being sued by tardies. They asked that question at everyone else, but it is not true that everyone else is asked similar questions about acquaintances with members of the defense. And for example, there are 4 people who admit to a relationship with defense witnesses and are asked only one question. So I think the real point is not whether or not there is a totally different response. There are differences in the responses. There are differences for two reasons. One reason is, as the court says in A.L.L, jurors are not cookie cutters, and so they won't have identical relationships with all of the parties. But the other reason is that the questioning is very different. And I think if the questioning of, for example, Carolyn, I believe it's Carolyn, no, it's Copper, is read, it's clear that's leading her, attempting her to get her to say, do you think it was a working relationship? Did you visit? No, but you did work with them? I don't think so. But I need you to be positive. Could it affect your thinking? It could. Is it possible? It's possible. Of course, she actually also had relationships with she volunteers a relationship with a prosecution victim.
When you said it could affect her decision, weren't they bound to follow up on a response like that?
Yes, Your Honor, but they didn't ask that. A follow-up, yes, there's no problem with following up, but that kind of questioning does not take place with black jurors. The leading of a person who might say, could it affect? Could it? I think if we're a human being, we say, could it? Could you put these things aside? Yes, that's not asked, and the questions, could it affect, are not asked of white jurors. And that's what, when I say there aren't identical white jurors who are seated and black jurors who are not. There's a reason for that.
Never asked any white jurors that question?
Never asked them in a leading fashion, no.
Not one?
I do not believe so.
And how many African-American jurors did they use that leading form with?
That form, I do not recall. I think there are 2. There are actually only 5, of course, who are struck.
You said a moment ago, I don't remember exactly what you said, but that there were 4 jurors. I think you said 4 white jurors.
4 white jurors who acknowledge a relationship, who each get only one question.
And what happened to those 4? Are they on the jury panel?
I believe I cannot recall if they were all seated. I can recall that the prosecution did not strike any of them.
But you don't know whether they're on the jury panel. I mean, the point is, if they're sitting on the back row and you know that you're not going to get that far in your jury selection process, why would you follow up with answers? I'm just...
Well, why would you not ask the same questions? Because I mean, if you're proceeding that far to voir dire, I assume you're concerned that there might be. But if you would like me to submit a supplementary brief about when they were questioned, I'm happy to do that. I frankly didn't.
My question is this. I assume by this point in the trial, and I'm not positive about that, but I'm assuming you're saying they've been through the challenges. We know how many are on the binary, and I don't even know that number right now, but we know that after strikes are made for cause, that we're going to have 12 jurors on this panel. The state's got 12 jurors to strike. The defense has got 12 jurors to strike. And so juror number 82, I'm not going to be nearly as concerned with questioning as maybe I would one of the first 12 jurors. And that's the only thing I'm asking is, those 4 that you reference, do we know whether they were tendered as jurors? Did they wind up on the jury panel? Were they in the... we just don't know, is what you're saying.
I am happy to supply that information to the court.
Well, I hope I can find it from the record myself.
But I think it's not all of them are that late, and I think the questioning overall is so wildly disproportionate, as is the investigation, outside investigation of these jurors.
Let's go back to the questions for a second. Is not the response just as important as the question?
The response is...
Let's take Diane, is it Copper that you mentioned? She worked with both Flower's sister for a year or 2. She worked with his dad a year or 2. Mm-hmm. She knew other members of the family well. She stated she leaned toward the Flowers case and knew several defense witnesses, and indicates that she lived right around the corner from them on her testimony. Matter of fact, she was asked to live on the same street. She said no. So, well, do you live on the corner of Cade and Harper? Well, yeah, I guess I do. Then they went into the question. So, what white juror got to sit in her place that had the same type of responses?
There are no white jurors that have precisely the same responses, in part because they are not questioned to that extent. And I want to say, she did not volunteer, I will be biased, when asked, could that affect your thinking in the case? She said it could. She also volunteered that her husband worked at Tardy's. So, I mean, had worked at Tardy's. So I think if we're talking about indicia of possible bias, I don't think it's reasonable to infer bias from what happened. But to me,
You say it's not reasonable to infer?
it is not reasonable to
Then
infer.
why is it reasonable to infer protection, misconduct by the prosecutor? Why should I get that inference?
You should get that.
Not so much that I get it, how the trial judge missed it. That's the real test, isn't it? What did the trial judge decide? Did he err?
Of course, Your Honor, I'm going to point out that the trial judge in Flowers 3 missed the bias that this court called the most egregious case it had ever seen. So trial judges make mistakes.
You're saying that was Judge Loper in this
It's
case?
not the same judge. No.
Well, let's talk about this case.
But I mean, all
What
I'm going
was
to
it
say,
about Judge Loper that he erred when he ruled, I accept those reasons? I want you to tell me definitively what the error is of the trial judgment.
the error is to look at that step 3 question, not step 1, not step 2, but step 3, looking at whether the defendant has met his burden of proving purposeful discrimination, of proving pretext. When we look at the entire record,
The defendant has that responsibility.
yes, he
Okay.
does. When we look at the entire record, including the extreme history in 2 trials, including the capital non-jury switch, including the disparate
You have a
questioning.
case to support that. She indicates that when you look at the past history, that a judge should look at that in order to determine whether prima facie evidence exists of discrimination. She cited 2 cases in Mississippi that stand for that proposition, that you look at that to get to the first level.
Well,
Do you
yes,
have any cases that talk about, which I think Justice Dickinson asked, that supports you look at that same discriminatory pattern when you're making the 3rd level decision?
so I would say 2 things of that. First of all, Miller-El does do that, and of course this
You
court...
say L says that?
Yes, but I think more, actually, this court says it in an indirect way because the strength of the prima facie case is one element in deciding whether or not pretext is present. So if you count it in establishing whether or not there's a prima facie case, and the strength of the prima facie case counts, I think that implies...
Are we not mixing things here? You're saying you use it to determine whether prima facie exists and examine the pretext. The pretext hadn't even been spoken yet because you get prima facie decision. Now state, tell me what your reason is before I can take step 2 to get
Yes,
the
but
pretext.
in step 3, the strength of the prima facie case is a factor. The court said that in Miller-El, and I believe this court has said that too, but whether it has or not, Miller-El says that the strength counts, and so by inference, since it counts in the prima facie case, it counts.
Are you trying to say that in a case where there's a very strong prima facie case, that the threshold for pretext is lower, and when there's a weak prima facie case, then the threshold for pretext is higher?
I wouldn't say it that way. The way that I would say it is that the Supreme Court has instructed us that we have to look at the totality of the circumstances in determining whether the defendant has proved purposeful discrimination. And so, if one element is stronger, then in order to meet that burden, the next element does not need to be as strong. And
Why is that different from what I said?
well, I'm not sure that it is. I said I would say it differently.
Okay.
But I think that it...
That's just the way I understand the law to be, and I'm trying to understand it. You're saying it's something different.
I'm saying everything counts together, and so when we do have something that's stronger, we need less on another indicia.
What was the final makeup of the jury?
1 African American
And 11.
and one alternate.
And the binary was approximately
It's 28% African American.
After strikes for cause.
After strikes for
It was
cause.
approximately 75%.
Yes.
Is there anything other than a generalized argument you make that specific to any of the 5 jurors that you complain of, Carolyn, Wright, Diane, Copper, Shea Cunningham, Edith Burnside, Francie Jones, anything unique about any one of those that's not unique to the other? That you feel like that person was
Not other than
purposefully discriminated against?
Not other than the mischaracterization. So if, that's why I think I will agree that they are not cookie cutters and that they do not say the same thing as an identical white juror, and there's not something that I have failed to say. Everything that I think the details that I have about each juror, the disparate questioning, the misrepresentation, mischaracterizations, I have nothing more than that. And I think together that takes it. Could I say one sentence more?
Wait just a second. Are there other questions? You may briefly summarize and conclude.
I would urge this court, if it reverses on improper arguments or identification or on Batson, to use its supervisory power to preclude another trial. The due process clause does not contemplate that a man should be put in jeopardy, that a man should run the gauntlet with his life at stake 7 times.
Thank you for your argument. The court will review the record in this case, the briefs, the oral argument that's been made, and render a decision in due course. The court will stand in recess until next duly reconvened. All right.